Thank you, Geoffrey. I think he's going to watch this on his computer. Hi, Geoffrey. This mural is aptly named The Progress of Human Knowledge. And Geoffrey has been the source of so much progress in the human knowledge about business and human rights that I'm delighted to be speaking in this speaker series. Geoffrey is the mentor of us all. And I also want to pay tribute to Chris and his fabulous team. Their role in this has been absolutely indispensable. Their openness, their transparency, seeking out different opinions. If an accusation is made against the company, seeking responses from the company, it's helped the dialogue immensely. And I'm, of course, also very grateful to you for hosting our portal. When you first agreed to do it, Chris, I'm sure you had no idea that there were going to be literally thousands and thousands of pages of documentation that you would have to sort through and put in the right categories and include in your weekly updates, which you have done so graciously. Thank you so much. And to add a historic note to the subject this evening, I understand that our location here, just off the Strand, is not far from where the first major factory stood in London. It was called the Albion Flour Mills, built in 1769. And together with the spinning and weaving plants that were sprouting up in Lancashire and elsewhere, it inspired William Blake's poetic lament over what he called these dark satanic mills. And of course, today the struggle for reform unfolds on a global scale, as we saw in the slides earlier from Maurizio. Business and human rights as a substantive issue goes back forever. The slave trade was about business and human rights, but as an issue on the international policy agenda, it was firmly implanted in the 1990s. And I think history will show that the last 2 decades of the 20th century witnessed perhaps the most dramatic implosion of space and time in all of economic history. The integration of China into the world economy, the collapse of the Soviet Empire, deregulation and privatization everywhere, created, among other things, the conditions for vast offshore production networks, which sometimes included dark satanic mills of their own. And at the same time, extractive companies, and I see representatives from several here tonight, were moving into ever more remote and difficult areas, often inhabited by indigenous peoples, resisting their incursion and were operating in host countries that were engulfed by the civil wars and other forms of serious social strife that marred that decade and in some areas continue today. These developments heightened social awareness of businesses' impact on human rights as never before, and as has been pointed out, it also attracted the attention of the United Nations. One early initiative, as has been mentioned, were the so-called norms on transnational corporations and other business enterprises, drafted by a subsidiary body of what was then the Commission on Human Rights. As Caroline has pointed out, it turned into a political football, but substantively speaking, my fundamental problem with the norms always was that they so intermingled the respective roles of businesses and governments that it would have been impossible to tell who was responsible for what on the ground. And I once described it as a full employment act for lawyers for generations to come, and lawyers don't need our help. At the end of the day, they make a good living without additional help from the United Nations. So we moved beyond the norms. This evening, what I would like to do is to share with you not only what I've tried to achieve, but in a sense to explain myself. I want to convey why I chose the path that I did, not always to universal applause, and to indicate briefly what the results are to date as I see them, and what my expectations are for the future. Now, let me begin with the process itself. The first and most critical step in any endeavor of this or any other sort is to be very clear about your strategic objective. Now, I set my strategic objective as achieving the maximum reduction of corporate-related human rights harm in the minimum amount of time possible. Now, that may seem obvious and unexceptional. I would guess that the authors of the norms held that view. But they also sought to subject an entire emerging area of business and human rights to a binding international instrument. Now, there's no a priori reason to assume that that path served the end of achieving the maximum reduction in the minimum amount of time. In fact, quite the contrary was much more likely, as Louise Arbour cautioned in an interview subsequently when she was High Commissioner for Human Rights. And I quote her, she said, "It would be frankly very ambitious considering how long this would take and how much damage could be done in the meantime." And of course she was referring to damage to victims. This temporal challenge, if I can put it that way, is compounded by the sheer magnitude of the mandate that Caroline burdened me with when she was on the UK delegation. It includes all rights holders, all companies, large and small, national and transnational. And if any instrument were to be effective, it would have to be implemented by all relevant states or enforced by some new world court for business. I frankly found it inconceivable that any meaningful instrument encompassing all these features could be adopted in today's world. And therefore, I set out on a different path. This is not to say that international law should not and will not play a significant role in the evolution of business and human rights. But I suspect it will be as precision instruments within a far broader array of policy measures, social strictures, best practices built from the ground up, not achieved by a piece of paper from the top down. So, maximum reduction, minimum period of time, primary objective. A second feature of my mandate process recalls Marshall McLuhan's famous dictum, "The medium is the message." In the UN context, I've taken this to mean that no matter how good your ideas are, the manner in which they are produced matters greatly. And despite the fact that UN human rights mandates are only minimally funded, when I began, my total budget consisted of 3 round-trip tickets from Boston to Geneva and a half-time person in the office of the High Commissioner. With this, I was going to solve the problems of business and human rights. Despite that fact, I started out on a path of extensive research and inclusive consultations, as has been noted. Now, in 2005, there was very little that counted as shared knowledge in the business and human rights domain. There is no, even to this day, no authoritative global repository of information. So anecdotal evidence ruled the day. For every bad news story alleged by an NGO, companies had good news stories about how much progress had been achieved through voluntary initiatives. Even the escalating number of cases brought against companies in national courts for alleged human rights abuses abroad settled little because so few reached definitive rulings. Today, if you visit Chris's website, you'll find enough research reports to fill a small library. on every subject relevant to the mandate that I was given. And that, I believe, has helped inform Human Rights Council debates. It has nudged protagonists to moderate their more excessive claims, of which there were many, and it provided a strong foundation for others to build on going forward. Inclusive consultations, of course, also matter. All stakeholder groups must be given the opportunity to be heard, victims consulted, the varying situations of different regions in the world and different sectors taken into account. And recommendations addressed to business actually have to find resonance there. Otherwise, they'll be ignored or opposed. And so business became part of the consultative process as well. And Chris mentioned the consultations that we've held around the world. By this time next week, they will number 47 international consultations since 2005. Of course, this is only made possible by, like Chris's situation himself, by the generous donations of supportive governments, the pro bono assistance of more than 20 law firms, for which I'm immensely grateful, several of which are here tonight, and by the engagement of all participants from all sectors in the process itself. The product of the process has been what we call a policy framework and guiding principles for its implementation. A policy framework which can serve as a common platform for action, on which cumulative progress can be built over time without foreclosing any promising longer-term developments. Let me say a few words about the framework and the guiding principles. There are many initiatives in the area of business and human rights, as you all know, but none had reached sufficient scale to move markets. And one major reason for that has been the lack of an authoritative focal point, a focal point around which the expectation of actors could converge. And therefore, when I was asked to submit recommendations to the Human Rights Council in 2008, I made only one, that it endorsed the Protect, Respect, and Remedy framework that I had developed following 3 years of consultations, so that there would be an authoritative focal point going forward. The Human Rights Council did so unanimously, which in itself is highly unusual. And it also marked the first time ever that any UN intergovernmental body had taken a substantive policy position on business and human rights. The framework, the Protect, Respect, and Remedy framework, as the title suggests, rests on 3 pillars. The state duty to protect against human rights abuses by third parties, including business, through appropriate policies, regulation, and adjudication. The corporate responsibility to respect human rights, which means to act with due diligence to avoid infringing on the rights of others and to address adverse impacts that occur, and greater access for victims to effective remedy, both judicial and non-judicial. The framework addresses the what question. What do states and businesses need to do to ensure respect for human rights? The guiding principles address the how question. How should they go about this? The draft is out for public consultation, as Chris mentioned. There are 29 draft principles in all, each with a commentary elaborating its meaning. At the end of the month, when the consultative period ends, I'll reflect on all of the comments that we've received from governments, from businesses, from NGOs, and then submit a final text to the Human Rights Council. In another relatively unusual development, this will not be a negotiated document. It's been outsourced to me, essentially, based on the understanding that there would be extensive consultations, but it will be my text, and it'll be voted up or down, and needless to say, we hope it's up. Now, I want to mention a couple of three or four of the key features that the framework and the guiding principles have to offer in advancing the practice of corporate respect for human rights. First, it's a comprehensive framework. Each pillar is an essential component of, if you will, an interrelated and dynamic system of preventative and remedial action. The state duty to protect, because it lies at the very core of the human rights system. You can't have an adequate international human rights system if states don't do what states are intended to do, which is to govern and to govern in the public interest, and specifically in the area of business and human rights, to protect against third-party abuse. An independent corporate responsibility to respect rights because it's the basic expectation that society has of business. Many of us expect more, but we all expect that when business goes about its business, it does so in a manner that does not hurt the rights of others. Build your mousetraps. Do whatever it is that you do, but don't infringe on the rights of others as you go about doing that. And access to remedy, because even the most concerted efforts can't prevent all abuse in advance. Second feature of the framework and the guiding principles is that they clearly differentiate the distinct obligations of states and businesses, so that the entire edifice won't collapse in on itself as the norms would have done if there had been an attempt to implement. I refer to the state duty to protect because international treaty obligations require states to protect against business-related human rights abuse within their territory or jurisdiction. And there are also strong policy reasons for states to do so, including for business activities abroad. For example, the principle that states should require adequate due diligence of companies before providing support for an investment overseas. Export credit agencies, for example, in the past have paid virtually no attention at all to the risks to human rights that investments that they supported would pose. That has to change. I refer to the corporate responsibility to respect rights rather than duty to indicate that current international law generally does not impose human rights obligations on companies directly. At the international level, the corporate responsibility to respect is a standard of expected conduct, if you will. It's recognized in virtually every voluntary or soft law instrument related to corporate responsibility, and it's been affirmed now by the Human Rights Council when it endorsed the framework. And as I said, the corporate responsibility to respect rights means to avoid infringing on the rights of others and addressing adverse impacts that may occur. The ability of a business enterprise to know and show that it respects rights requires something of the business. It can't simply say that they respect rights. That's just a claim. That's not a fact. To establish it as a fact, a company has to conduct what we have called human rights due diligence, to actually look at the impacts that they have on people and communities in which they operate, and to take into account those impacts and to remediate them as the need arises. This notion of human rights due diligence, Andrew Vickers from Shell, I think, is here tonight. There he is. He gave a speech at The Hague not long ago, which I had the privilege of attending. He used a brilliant, brilliant analogy. Andrew said words to the effect, no petroleum or mining engineer would ever dream of drilling a hole in the ground without conducting extensive seismic analysis What companies now need to acquire is social seismic skills. Bravo, Andrew. And I warned you at the time, I'm going to steal that line and use it endlessly. Now, let me be clear that it's the adverse impact on internationally recognized rights of a business's own activities and relationships that it needs to be concerned with. Mere presence and paying taxes in a bad country, in quotation marks, does not contravene the corporate responsibility to respect rights. Being involved in the bad things does. And that's where the human rights due diligence comes in. Whether it's security forces that protect company assets, whether it's suppliers from which they procure goods or services. The third feature, and this may seem a bit on the academic side, but it's profoundly important. Let me describe the third feature by using a metaphor myself. The guiding principles in the framework don't rely on any presumed hierarchy of international legal norms. They seek to promote more effective connectivity, that's the metaphor, as the surest drivers of better human rights performance. What I mean is more robust horizontal linkages within states, within business enterprises, between states and businesses, and between businesses and their external stakeholders. Now, what's the academic part of this? Well, human rights discourse is animated by the premise that human rights trump other kinds of claims. I support this fully as a moral argument, and I cherish its effectiveness for advocacy and empowerment. But this presumed hierarchy carries over into the international legal realm in only limited circumstances in relation to such norms as the prohibition against slavery or genocide or war crimes or crimes against humanity. And most business-related human rights harm don't fall into that category. So the presumed hierarchy, whether or not you believe it exists, doesn't take you far enough in the area of business and human rights. And that's why it's so important to push the notion of better connectivity. At the same time, the International Law Commission has identified a prevalent feature of international law that is enormously consequential for business and human rights, namely that the international legal order is increasingly fragmented into separate and autonomous legal spheres and tribunals. In an influential report to the UN General Assembly, the International Law Commission concluded, and I quote, "No homogeneous hierarchical meta-system is realistically available." I didn't make up those words, they did. "No homogeneous hierarchical meta-system is realistically available to resolve the problem of incoherent and incompatible provisions." There's no international Supreme Court that you can go to say, this trumps that. So what do you do? A recent investment tribunal ruling in a case that was brought by international water companies against Argentina illustrates the case perfectly. And I quote from the ruling, "Argentina and the amicus curiae submissions received by the tribunal suggest that Argentina's human rights obligation to assure its population the right to water somehow trumps its obligations under bilateral investment treaties, and that the existence of the human right to water also implicitly gives Argentina the authority to take actions in disregard of its bilateral investment treaty obligations. The tribunal does not find a basis for such a conclusion either in the bilateral investment treaty or in international law. Argentina is subject to both international obligations, that is, its human rights and bilateral investment treaty obligations, and it must respect both of them. In other words, sorry, Argentina, it's up to you to figure out how to reconcile conflicting obligations. And of course, one way to do that is not to sign bad contracts with companies in the first place, on the basis of which they can then drag you into binding international arbitration. Connectivity. Connectivity within governments. Perfect example, South Africa, a case that I have talked about before. The Foresti case. European investors sued South Africa under binding international arbitration, claiming that certain mining provisions of South Africa's Black Economic Empowerment Act amounted to expropriation, for which the investors sought compensation. The South African government was stunned. There was nothing more important than the Black Economic Empowerment Act to rectify historic inequalities in South Africa. And all of a sudden, investors from Luxembourg and Italy were suing them for adopting this legislation demanding compensation. The South African government convened an inquiry to essentially address the question of how did we get ourselves into this situation in the first place? Well, among other reasons, the review found, and I quote, the executive had not been fully apprised of all the possible consequences of bilateral investment treaties, unquote. Connectivity. The people who were in charge of investment promotion never talked to and had no idea what the country's human rights obligations were, or even what its domestic human rights policies were. Better connectivity within governments, essential to making progress. The same holds for companies. Better connectivity within companies. Where responsibility for human rights is segregated in an outward-facing CSR department, cosmetic compliance is the most likely result. Meaningful change happens when the responsibility to respect is integrated into all relevant business functions, and the results are reported back to wherever oversight for real compliance rests within the company. Connectivity. Better connectivity is required between states and firms, not necessarily more regulation, but smart regulation. We're emerging from an era in which many governments assumed they were doing business a favor by failing to provide adequate guidance for managing the human rights impact of business activities, even in the most high-risk contexts. Some governments also mistakenly believed that by outsourcing the delivery of social services to the private sector, they thereby also outsourced any human rights obligations attached to those services. In many cases, in many countries, it was water. In my country, it was prisons. Prisons were privatized. And the state thought, okay, well, we've privatized the delivery of the service, we're no longer responsible. Wait a minute, that's not quite right. You still are responsible. Better connectivity between business and government. And better connectivity is required between firms and the communities in which they operate. Here, in addition to the important role played by stakeholder engagement generally, I've stressed the utility of legitimate and effective operational level grievance mechanisms. Mechanisms whereby companies in the communities in which they operate, we have 5 pilot projects going on, including one on Sakhalin Island in the Russian Federation, one in South Africa, one in Colombia, one in Vietnam, where the company actually establishes with community cooperation, site-level grievance mechanisms, complaints processes where people can go and where they can complain without having to organize campaigns, file lawsuits, and deal with issues that can be dealt with in such a manner in an early fashion before escalation into really serious human rights abuses, which has often happened because companies ignore more minor issues. Maurizio has heard me say this before. I had a conversation once in a few years ago with a community organizer in Peru who had closed down, who organized the community to close down the only access road to a mine. And nothing went in and out for a week or more. Security forces were called out, shots were fired, and you can finish the scenario because it's happened in so many other places. I asked the community organizer, what brought you to do this? And his response is seared in my memory. He said, they paid no attention when we came to them with small problems, so we created a big one. Site-level grievance mechanisms can help cut that short right from the start. A fourth feature of the framework and guiding principles is that it takes into account context and size. For example, there will be situations, and we all know what some of them are, where national law conflicts with international standards, and where a company is put in a situation of either complying with the law of the land that it's in, or meeting its responsibility to respect human rights. Freedom of association, unions not permitted, internet privacy, censorship required. What is a company to do in such situations? Context here matters. What we have suggested is that companies are expected to find ways to honor the spirit of international standards without violating national law, unless, of course, that legal compliance results in breaching international sanctions or involves companies in the commission of or contributing to international crimes. Size also needs to be taken into account. A mechanism or a policy or an approach that works for a company that operates in 190 countries and has 300,000 employees isn't going to work for a company which may be multinational but only has 100 employees and exports pumpkin seed oil from Austria to the United States. So context and size matter, and that needs to be taken into account. Finally, the framework and guiding principles address a fundamental reality of global business operations today. A core challenge of business and human rights lies in the governance gaps created by globalization itself. Between the scope and impact of economic forces that span borders and jurisdictions, the capacity of societies to manage their adverse impacts inside those borders. Therefore, any credible response has to address the thorny but important issue of what is known as the extraterritorial application of national jurisdiction. Again, I didn't make up those words. What it means basically is applying one country's rules to govern activities in another country. We call it fondly ETJ. I noted in my 2010 report to the Council that complex and legitimate issues are at stake here, and they're unlikely to be resolved anytime soon, but they can't be ignored. Extraterritorial jurisdiction is on the agenda. Now, my friends at Amnesty International find that the ETJ references in my guiding principles are, quote, entirely inadequate, unquote, claiming that they understate current international legal obligations of states. In contrast, my friends at Talisman Energy, through the law firm that has defended them in a US Alien Tort Statute case, find that the guiding principles go too far, that they exaggerate existing standards. To me, the juxtaposition of the two suggests that on ETJ, the guiding principles pass the Goldilocks test. Ah, she said, this porridge is just right. So what's in the porridge when it comes to ETJ? Essentially, three things. First, I make the empirical observation that at present, states are not generally required under international law to regulate the extraterritorial activities of businesses domiciled in their country, but nor are they generally prohibited from doing so, provided there is a recognized jurisdictional basis and that the exercise of that jurisdiction is reasonable. I go on to observe that within this permissible space, states have chosen to act in the area of business and human rights only in very exceptional cases, and they do so very unevenly. And I point out that this is in contrast to other areas related to business, such as anti-corruption, antitrust, money laundering, child sex tourism, and some environmental regimes, several of which have become subject to multilateral agreements. Second, I argue that some measures that typically get lumped into the ETJ category shouldn't be there at all. That they are properly described as domestic measures that have extraterritorial effect. For example, in my judgment, securities regulators are entirely at liberty of imposing listing requirements to protect domestic investors, no matter what their spatial reach may be. Anybody who wants to be listed in the United States, no matter where the investor comes from, has to meet certain requirements. There's no reason why that can't be certain transparency requirements with regard to the company's human rights policies or practices. A specific requirement may be considered onerous or counterproductive, but I don't think it can be challenged on jurisdictional grounds. The same is true for what can be described as parent company-based regulation. For example, where a state requires a parent company, the Canadian government requires a Canadian parent company to exercise greater scrutiny over the overseas activities of that Canadian company's own subsidiaries. Again, a particular requirement may be a good or a bad idea in practice, but I don't see a strong jurisdictional issue. Third, with regard to extraterritorial jurisdiction, I asked the question, what do we want to say to people in areas affected by armed conflict over the control of territory or resources or the government itself, which in fact is where the most egregious human rights violations related to companies have taken place and where illicit enterprises flourish? What do we want to say to those people? Too bad? Sorry, work it out yourselves? Or that governments, business, and civil society need to come together to make sure that these are not law-free zones, that in fact there should be no law-free zones anywhere on the face of the planet. So that's what's in the ETJ porridge. Let me conclude. I've gone on for far too long. I said at the outset that my strategic objective was to achieve the maximum reduction in corporate-related human rights harm in the shortest possible period of time, and do so by establishing a common platform for action on which cumulative progress can be built. I've called this approach principled pragmatism, and tonight are my confessions. I think the approach appears to be bearing some fruit. The framework, the Protect, Respect, and Remedy framework, has acquired a life of its own even before the guiding principles have been finalized. Within the UN human rights system, it's been used extensively by the special rapporteurs on the right to food, water, health, on the rights of indigenous peoples, as well as on toxic wastes. Beyond the UN, the framework has served as the basis for the human rights chapter in something called ISO 26000, which is a social responsibility guidance recently adopted by the International Organization of Standards, with 94% of ISO member bodies voting in favor, including China. China has endorsed a social responsibility standard that has a human rights chapter in it that's based directly on our framework. The framework has played a significant role in persuading the OECD Council of Ministers to consider adding a human rights chapter to the OECD guidelines on multinational enterprises. The current negotiating draft closely tracks the relevant framework provisions, and one reason for that is that we've been asked to participate in the process. Countries ranging from Norway to South Africa have used the framework in their own national policy assessments. Human rights organizations ranging from the Cambodian Center for Human Rights to Amnesty International have drawn heavily on the framework in their own advocacy work. Workers' organizations have invoked it, and there's been a welcome outburst of activity among leading companies to determine if their policies are, quote, Ruggie-proof, unquote. Again, it's not a phrase that I invented. You'll find a framework in action entry on CRIS's website, which demonstrates, I think, that a broad spectrum of countries, businesses, and civil society actors are actively engaged and supportive of the basic direction in which we're heading. Now, the tasks for the next phase are clear. Further embedding and disseminating the framework and guiding principles, sustaining multi-stakeholder dialogue and support, making sure that this doesn't get derailed and go back to the normist days, helping to build capacity of all relevant actors, including small and medium-sized enterprises and governments, and fostering improved conflict management and dispute resolution. Now, I'm under no illusion that this will bring business and human rights challenges to an end, but if we succeed at the Human Rights Council in June, it will mark the end of the beginning, if I can borrow a phrase from Winston Churchill. We need Human Rights Council endorsement of the guiding principles to lock down the gains and to sustain the momentum. And for that to happen, all hands must be on deck and rowing in the same direction. This is no time to let the elusive quest for perfection, however you define it, to become the enemy of the good. This is no time to allow narrow institutional interests of whatever segment of society you represent to stand in the way of achieving results. Nor is it the time to subject hard-won consensus to unrelated political bargaining. Progress is precious. We can't let it slip away. Thank you for your interest. Thank you for your engagement, and have a safe journey to a better future.